Major breaking news. The United States Supreme Court, in a 6-3 decision written by Justice Clarence Thomas, has declared that the ATF's bump stock ban is illegal and unconstitutional, that the ATF exceeded their authority in redefining a bump stock as a machine gun, and where it is simply not a machine gun as defined by Congress in the National Firearms Act. This is a major win with huge admissions by, believe it or not, the anti-gun liberals that's going to come back and bite them on the dupa. We're going to talk all about this when we get back. A huge win for the Second Amendment. I cannot stress this enough. What a big deal this is, not only for the Second Amendment, but also for those of us who want to cut back on the authority of the federal government and the ATF when it comes to restricting our constitutional rights. We're going to talk all about this when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Attacks Teach Americans About the Right to Bear Arms. We must always learn from the mistakes of others. The Israelis made a huge mistake in not allowing their citizens to be fully, robustly armed the way we are in America. They don't have a Second Amendment, and all the mistakes they made by failing to never forget the critical lesson of the Holocaust and World War II and the Jewish history, which is don't allow yourself to be disarmed by any government. And don't trust the government to come to your rescue, because the old saying that when seconds count, police are minutes away, that applied in Israel on October 7th, where when seconds counted, literally the government in almost all instances was hours, if not days away. Critically important Second Amendment related information in that book, Israel Disarmed, for Americans to learn these lessons. All right, folks, so major breaking news. The U.S. Supreme Court has said that the bump stock ban is unconstitutional. Now, this has massive implications in our favor for the Second Amendment all across the board, because this is signaling to me, I'm going to tell you what I think it signals, and then we're going to break down the decision. This is signaling to me that the U.S. Supreme Court, as I previously predicted, is going to declare the Chevron Doctrine, which is really the deference to government doctrine, to be illegal. They're going to wipe out the Chevron Doctrine and no longer allow courts to defer to interpretations of agency rules, regulations, and statutes. They're no longer going to give deference to these regulatory agencies, or some of you may refer to them as the deep state agencies, whatever you want to call these. This is a signal that the Chevron Doctrine is dead on arrival. It's going to be bye-bye in a matter of a few weeks. That's the first thing this signals. The second thing, and this is a huge deal for those of us who think that AR-15s are clearly protected by the Second Amendment, which they are, massive deal here. The opening line by the 6-3 Supreme Court specifically and unequivocally states, as I predicted based on the 1994 decision by the Supreme Court in United States versus Staples, that machine guns and semi-automatic rifles are entirely different. Now, you in the gun community totally understand this. You're rolling your eyes like, come on, Mark, we all know this. No, we don't all know this. And what I mean by that is you and I may know this, but the Supreme Court people trying to dupe, in my view, the Supreme Court into thinking that a semi-automatic rifle is the same as a machine gun because it can be readily converted, supposedly, into a machine gun. Now, that is clearly hooey, but this is a sort of rationale and reasoning that we've been seeing out of like the United States Court of Appeals for the Fourth Circuit in the Kobe case years ago. Also the Seventh Circuit, Judge Wood and Judge Easterbrook, those terrible anti-gun judges out of Chicago. This is the kind of reasoning. Now, this language I'm going to read to you, to me, the two things I'm about to read to you in some ways are the most important parts of the decision outside of the fact that we won the case. The first is the opening line by the court that speaks specifically to this issue. The machine guns and semi-automatic rifles are totally different. This is a hugely important distinction that now we understand, that this Supreme Court recognizes this difference. This is a very big deal for those of you out there fighting AR-15 bans. Here's what the Supreme Court wrote in today's case of Cargill versus Garland. Congress has long restricted access to machine guns, a category of firearms defined by the ability to shoot automatically more than one shot by a single function of the trigger. Semi-automatic firearms, which require shooters to re-engage the trigger for every shot, are not machine guns. That is a huge statement in the opening line of this decision of Michael Cargill versus Garland. By the way, we have to congratulate the National Civil Liberties Alliance and Michael Cargill for fighting for our rights. Congratulations, a huge win before the Supreme Court. We congratulate both of you and all the people that worked on this bump stock case all the way up to the Supreme Court. It takes years to get there, and I'm happy to say a major win 6-3 with Justice Barrett, Justice Kavanaugh, Justice Gorsuch, all in the majority, knocking out the ATF. Those are 3 Trump-appointed judges. For those of you who want to know why you should vote for Donald Trump in the fall to protect our Second Amendment rights, all you need to do is say and think Gorsuch, right? Gorsuch, Barrett, and guess who? Brett Kavanaugh. Today's decision illustrates why President Trump deserves a second term, in my opinion. Anyway, we'll talk more about that in a future video. Now, here's the other critical, this is a huge win for us because of a major mistake. Maybe it wasn't a mistake, but it seems like it was a concession that the lefties didn't need to make. The lefties have conceded that semi-automatic rifles are basically commonly used. As you know, under the Supreme Court's Heller precedent, which is reaffirmed by Bruin, the in common use test says that if a particular type of firearm is in common use by Americans for lawful purposes, it simply cannot be banned. Now, here is what the 3-judge dissent, Justice Sotomayor, Justice Kagan, Justice Brown, said about semi-automatic rifles. It's a devastating admission against their interest and hugely favorable to the Second Amendment community. Let's see what they say. Let's go to the scoreboard. The dissent says, quote, this is about the Stephen Paddock issue, of course, in Vegas. Quote, within a matter of minutes, using several hundred rounds of ammunition, the Las Vegas shooter killed 58 people and wounded over 500. Here's the key line, folks. He did so by affixing bump stocks to, drum roll please, commonly available semi-automatic rifles. Bing, 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 bing. He did so by affixing bump stocks to commonly available semi-automatic rifles. Folks, that's not from me, the Four Boxes Diner. That's not from you, the smartest person in the room, because you watch the Four Boxes Diner Second Amendment channel. It's from the anti-gun liberals on the U.S. Supreme Court. They've essentially admitted that AR-15s, which are, of course, semi-automatic rifles, are, guess what, commonly owned. They're commonly available. They're common. They have conceded the point that these things are readily available, which is a no-brainer because they clearly are. That's why the anti-gunners hate them, because AR-15s and semi-automatic rifles are ubiquitous. Hello? But it's great to see that in an anti-gun dissent in the U.S. Supreme Court in this Cargill case. That, I promise you, is going to find its way into every single gun ban brief going forward, dealing with semi-automatic rifles. You got the prediction right here and right now. And by the way, yes, I did predict that we would win the bump stock case, but we'll talk about my prediction record at the end of the term to see how well I did. So far, perfect score. Fingers crossed. Let's keep it going. Next major prediction, as you know, is that Justice Alito is going to write Rahimi, which will be very good for us, but time will tell. Okay, so let's turn back to the Cargill case. Other major things that the court said here includes, this is what Thomas says, again, distinguishing between semi-automatic rifles and automatics. He writes, no one disputes that a semi-automatic rifle without a bump stock is not a machine gun because it only fires one shot, i.e. one shot per function of the trigger. Huge statement. Again, we at some point can talk grammatically about the function of the trigger, but it's pretty clear that the Fifth Circuit got this right, and the Supreme Court 6-3 reaffirmed that. Then it goes on to say, and you got to check this opinion out, you got to give the Supreme Court credit. You know, some of you have criticized Justice Barrett. I understand it. In some ways, maybe I would like her to be more aggressive in certain respects on certain occasions, and same with Justice John Roberts, Chief Justice John Roberts. But the reality is, I do think that both Chief Justice John Roberts, Justice Amy Coney Barrett, Justice Kavanaugh, Justice Gorsuch, when push comes to shove on these major issues, I always think they get to the right answer on the merits. Sometimes I think they give a little bit too much deference on stay questions and delaying things in emergency applications. I might give less deference to the government than they do, but the truth is, so far, knock on wood, they're doing great on the merits, which is very important. Now, again, here's another great statement from this opinion. Hugely, it says, quote, a bump stock does not convert a semi-automatic rifle into a machine gun any more than a shooter with a lightning fast trigger finger does. Did you hear what I just said? They're basically saying that the rate of fire, the rapidity of firing, does not mean anything as to whether or not something's a semi-automatic rifle or an automatic rifle. This is a big deal because, and we'll talk about this in a separate video, What the anti-gun community, let me be clear, what the anti-gun community wants to do to ban our guns is they want to equate rate of fire with being a machine gun. Even though if you look at the definition of machine gun in the federal statutory law, rate of fire or rapidity of fire is not in the definition of machine gun. You can have a super slow machine gun and a super fast semi-automatic rifle. It doesn't matter. It doesn't change the characteristics from a machine gun to a semi-automatic rifle. So if you set up a machine that automatically and mechanically fired one shot every like 3 minutes, that's super slow, right? But that is still technically a machine gun if it's automatically firing without another pull of the trigger. See? In contrast, some of you out there shoot semi-automatic rifles and weapons really, really fast because you're really good, and that's great. But the point is that's irrelevant to the definition. And just as a reminder, the reason why the Trump administration wanted to ban the bump stocks through the ATF process and not let Congress try to ban them is because there was a great fear that if Congress tried to redefine machine guns, it would include this rate of fire concept, and that would bring within the umbrella of that definition all sorts of semi-automatic rifles like AR-15s. And frankly, the Trump administration said and thought that it would be safer for all of our rights, not just the bump stock issue, if they put forth kind of a weak-kneed, kind of wishy-washy ATF ban on bump stocks and allow that to be litigated, as opposed to let Congress pass something that would definitely 1,000% screw it up. The only other point, and we're going to talk a lot more about this, is Justice Alito had a very good concurrence. We're going to talk about the meeting there. He basically is saying that, hey, if you want to ban stuff, if you want to pass legislation, you got to do it with we the people, the legislature. Congress has to act. I don't think there's anything problematic in that concurrence. Justice Alito was great on the Second Amendment. I don't think I'd read anything problematic into that. He's essentially saying that if Congress wants to ban bump stocks, then let them do it the right way and not try to do it through the back door through bureaucratic regulation. And that is clearly the right answer for separation of powers. And that doesn't mean it's constitutional, by the way, under the Second Amendment. But if they want to do it separation of powers wise, let them do it the right way. And the last thing I want to bring to you is this is an interesting point that Judge Sotomayor brings up in her dissent. She says, quote, "When I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. A bump stock equipped semi-automatic rifle fires automatically more than one shot without manually reloading by a single function of the trigger. Because I, like Congress, call that a machine gun, I respectfully dissent." Of course, that's entirely stupid because, as you know, you have to manually manipulate a firearm with a bump stock on it to make the thing bump fire. And it's not the bump stock, it's the technique. And it requires multiple hands and multiple pressure points and everything else. And thus, it's not simply the single function or the single pull of the trigger. That's what the ATF has always said up until this issue. And now it's good the Supreme Court says, hey, this is what the statute says. So anyway, we'll talk a lot more about this and what it means, but the bottom line is this is a huge, huge win for the rule of law in America, for the separation of powers, and for freedom and for gun rights in the Second Amendment. It also cuts back dramatically on ATF authority. All of these things I did predict. Again, we're going to wait to see how I predict and see if you guys think I did a good job at the end of this term. But, next man up, of course, is Justice Alito knocking out the Rahimi, dealing with the Rahimi case. I think that's going to go okay for us. And don't forget, we got to see if the Chevron Doctrine is wiped out, and I think it will be very soon. So there you have it, folks. Major breaking news. We'll talk more about this case later. Don't forget to subscribe to Four Boxes Diner. Follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.